plethora of law review articles that have been published. Mr. Blackman is a leading conservative thought leader, and today he's here to talk to us about the current status of the Second Amendment. We are very fortunate to have him back, as if you remember, he came and debated Professor Rosen last semester over the constitutionality of the Texas Heartbeat Act. And so with that, if you will please join me in giving Mr. Blackman a round of applause.
Thank you so much, JC. It's a pleasure to be here. The last time I was at Tech was in November. It was November 1st, wasn't it, JC? It was November 1st, and that was actually a lousy day for me because in the middle of my presentation, I got a message that my aunt had been admitted to the hospital. So the second half, I was completely zoned. I didn't know where the heck I was. I know I spoke to you. I know I said stuff, but I have no actual recollection of speaking it. So it was a really weird day. So I'm actually very happy back here under happier circumstances. The topic for today is the current state of the Second Amendment. And I speak to you at something of an inflection point. The Supreme Court's approach to the Second Amendment has remained somewhat static, or in flux even, for the better part of the last decade. But now the court is poised to decide a case that could settle, or perhaps at least resolve, where the Second Amendment is headed. So my goal for today is to sort of walk through where Second Amendment law is, where it started, and where it's headed. Okay? The starting point, of course, or discussion is 1791. The Second Amendment was ratified. It provided a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms will not be infringed. For much of early American history, the Second Amendment didn't have much salience. The federal government didn't really enact many gun control laws, and the issue of the militia sort of just faded over time. But then we started getting to the 19th century, and states began to enact various gun control measures, but not for reasons that you might think. Some of the earliest limitations on guns in the United States were actually part of the Jim Crow laws. They were designed to prevent slaves and later freed slaves from carrying arms. These laws were meant to make it easier for the Klan and other racist groups to go after them and to lynch them. Okay. The next data point I actually want to discuss is a case you may be familiar with, Dred Scott versus Sanford, which is not a usual case to talk about, but it's very important. In that decision, Chief Justice Taney held that people of African descent could never be citizens. And he gave a reason why, which is often forgotten. Taney said that if Dred Scott, a black man, was a citizen, then he would be entitled to the right to keep and bear arms as a privilege of citizenship. And so Taney basically said you cannot grant these people citizenship because then they could have guns. But I think that reflects, it's interesting that keeping arms was a right of citizenship even at the time of the Dred Scott decision. Fast forward to the Civil War, and after the Civil War, Congress enacts a law called the Freedmen's Bureau Act. This is a law passed in the wake of the 13th Amendment that guaranteed the freedmen certain rights. The right to serve on juries, the right to make and enforce contracts, and the right to bear arms. So again, you have the Congress that ratified the 13th Amendment, that approved the 13th Amendment, putting in a statute saying that the right to bear arms is an essential right. Keep going further. In 1868, the 14th Amendment is ratified. This amendment guarantees what we now know as birthright citizenship, guarantees equal protection of laws, guarantees the due process of law, but also guarantees the privileges or immunities of citizens of the United States. What are these privileges or immunities of citizens of the United States? I can give an entire lecture on that specific point. I can make a more general argument. The privileges or immunities include those provisions enumerated in the Bill of Rights. Not a particularly controversial provision. Most people, even who don't like substantive due process, accept this point. If the right to bear arms is a privilege or immunity of citizens of the United States, then the states can't deprive them of those rights. Okay, fast forward to 1875, go to Louisiana. There was a dreadful incident called the Colfax Massacre. The facts are gruesome. It was a local election, and the African Americans who were Republicans thought they won, and then the white Southerners who were the Democrats thought they won. How was this election resolved? No, not in the courts. Actually, it wasn't a court. The white mob basically cornered the freedmen in the courthouse, and they lit the courthouse on fire. And they burned these people to death. And those who escaped from the building were shot and dragged down by the river. Now, why is this incident relevant to discussion of guns? Before that happened, the lynch mob prevented the blacks from having arms and from gathering and assembling. It's a dreadful incident. After this incident happened, the federal government brought a prosecution, arguing that this lynch mob deprived the freedmen of the right to bear arms and of the right to peacefully assemble. That is, the lynch mob violated both the First and the Second Amendment rights of these people. The Supreme Court ruled against them in a case called Crookshank against the United States. And the upshot of Crookshank is that this right to bear arms was not a privilege or immunity of citizenship. In fact, the court had recently held this provision, the Privileges or Immunities Clause, had no teeth. Okay, so why am I giving this history with all these sort of disparate points? The notion that there's a right to bear arm that's not connected to militia service was pretty well established, I think at least, in 1791. But the right became even stronger when the 14th Amendment was ratified. This was a personal right that was not connected to militia service. All right, so let's jump now to the 20th century and the 21st century. The Second Amendment said very little, the Supreme Court said very little about guns during the 20th century. There were a couple of cases about what kind of arms might be protected, a case called Miller, a very weird case involving short-barreled shotguns, but the court didn't really say much about it until we get to 2008, a case called DC versus Heller, right? Heller was a case involving the District of Columbia. DC was one of the few places in the country that completely banned the private ownership of handguns in the home. In 49 states, you had a right to keep a gun in your house. The only outliers were Chicago, Illinois, and the District of Columbia. And DC argued that they had no obligation to protect any right for people to keep a gun in their home. You might be able to keep a long gun in your home that be locked up, and actually you unlocked your gun, you were committing an offense. So you basically had no right of self-defense in the home. Okay, then we have Dick Heller. Who's Dick Heller? He lived in DC, and he was a security guard. And not just any security guard, he provided security for the federal courts. He guarded judges. During his job, he was allowed to keep a gun at work to save the life of federal judges. But as soon as he got home, he could not use a gun to defend himself and his home. Dick Heller took what you might consider a futile act. He went to the police station and said, I would like to register a handgun. They said, you idiot, you can't. It's against the law. He's like, okay, that's fine. Just deny me. That is what we call standing, right? He went to apply for a license. He was denied that license. And then he sued. Now, at the time, there was no guarantee that the courts would rule in favor of the Second Amendment. In fact, the National Rifle Association, the NRA, was not in support of this case. They were worried that a loss at the Supreme Court would doom gun rights forever. The NRA was saying, look, we'll just keep the sort of status quo where it's not really clear, but at least we can fundraise off it, right? They were actually, sorry, that's mean, but they were actually more comfortable, it's true, they were actually more comfortable with the sort of status quo they could just sort of politic on and actually getting a constitutional ruling. The case was not brought by the NRA. They like taking credit for it, but that wasn't their case. It was brought by a couple of lawyers who believed in the Second Amendment. Robert Levy, who's an alum of my law school, Clark Neely, who's now at the Cato Institute, and Alan Gura, who was my co-counsel for many years. There were three lawyers in Washington, D.C., who brought this case basically on their own. And their mission was to get the Second Amendment recognized. The trial court, they lost, but they prevailed at the Court of Appeals. And the DC Circuit actually held for the first time that the Second Amendment protects a right to keep and bear arms in the home. That this is not a right connected to malicious service. And then DC had a choice. DC could have done nothing and said, okay, we'll just give Dick Heller his gun license, which is probably what they should have done. But instead, they decided to appeal to the Supreme Court. If they had done nothing, there would have merely been a circuit precedent that would not have applied nationwide. But by appealing to the U.S. Supreme Court, the District of Columbia basically risked, and in fact, we know they did, create a nationwide Second Amendment precedent. They shouldn't have appealed. They should have just kept the case local. But look, it's hard, right? It's hard to accept defeat, so you appeal. And aside, with the current Supreme Court, one of the best strategies is not to appeal if you're a progressive group, just to keep it away. Keep cases away from the Supreme Court. Back to the topic at hand. The case goes to the court, and the question is very simple. Does the Second Amendment protect a right to keep and bear arms? Now, most people think they know what the two options are. Yes, it's an individual right or a collective right, but it's actually not so easy. Throughout the 1970s and 80s and even the 1990s, progressives argued that there was a collective right. That is, the Second Amendment was the right of militias to keep guns, right? It was the right of a militia. And that argument sort of faded because it never made much sense. It speaks about the right of the people, right, to bear arms. And if you look at history, people usually kept the guns in their own possession. They weren't being stored in some sort of like government warehouse. That just never happened. So in the late 90s, early 2000s, gun control advocates pivoted. They picked a new position. The new position was that, well, you have a right to keep and bear arms individually for service in a militia. It's an individual right to keep a gun so you can use it in the militia. It's not for hunting. It's not for defending your home. It's you keep a gun in your house, and if the militia calls you forward, you then use that gun for service of the government, right? And that wasn't this sort of the states' right model where states had this militia. It was a very weird conception. This goes to the Supreme Court, and by a 5-4 vote, the Supreme Court rules in favor of the individual right model. The notion that this is a right that it pre-existed our government, it was a right to bear arms for defense of yourself, that was not connected to militia service. Then we have this sort of this textual issue, right? You have this clause saying a well-regulated militia, and this other clause saying this, the right of the people to keep their arms, right? And how do you reconcile this text? And what the court basically said was the preamble, the prefatory clause, did not control the operative clause, that these were separate concepts. And we look at things like the English Bill of Rights and other documents. The Second Amendment was protected even in places where there was no militia. State constitutions, which didn't have any sort of militia need, still protected the right to bear arms. I think on balance, Heller was correct. You can argue about this all day. I think the position by Justice Stevens' dissent never made a lot of sense. The exact right he was sketching just seems so contrived that this right to only keep a gun in a house in the event of a call from the militia, there's very little to support it. He relies a lot on sort of the drafting history of the Second Amendment, but doesn't look to the antecedent provisions that came before it. Okay, that was Heller. DC's handgun law was declared unconstitutional. All right, what happened next? Almost immediately after Heller was decided, I'm talking within like an hour, another lawsuit was filed in Chicago. It was followed by the same group, the Alan Gura lawyers, and they challenged Chicago's handgun ban. But now the NRA got in the act. The NRA said, okay, let's try and take some credit here. So they had NRA versus Chicago. The other case was McDonald v. Chicago. Otis Mcdonald was an African-American man, elderly, I think he was in his 70s at the time. And he just wanted to defend his family. He lived in a rough neighborhood of Chicago. I think they're all kind of rough. But he lived in one of the rough neighborhoods of Chicago. And he wanted a gun to defend himself and his family. I met him once. He was a lovely human being. Very, very, very. He died about 2 years ago. So he was a very, very decent man. But he just wanted a gun to defend his family. Wasn't a lawyer, but he believes strongly in this right. Okay. So then the question becomes one of incorporation, right? The Bill of Rights, the first 10 amendments, do not on their face limit the state governments, only limit the federal government. But the 14th Amendment changed that, sort of. Starting in the late 19th century and throughout the 20th century, the court began to sort of piece rights fundamental to limit state power. They sort of selectively incorporated the provisions of the Bill of Rights to limit state power. But one of the few outliers was the Second Amendment, right? There was no need to incorporate the Second Amendment because it didn't really mean anything. But then we get to McDonald. By the time McDonald comes up, virtually every provision of the Bill of Rights had been incorporated except for grand jury indictment, the civil jury requirement. There's a unanimous jury requirement, which came a couple years ago. A handful of provisions, but virtually everything was incorporated. In any normal constitutional law, if you look at the body of precedent about incorporation, the Second Amendment should be a slam dunk, right? It's enumerated, has deep roots, right? It's fundamental by any definition. But again, the court split 5-4. Justice Stevens, Breyer, Sotomayor, and Ginsburg argued that the Second Amendment was not a fundamental right. It did not warrant incorporation. That was just, that was a decision. They didn't like guns. It's hard to justify that's a matter of constitutional law. It should have been incorporated, right? By any test we've applied, this one should be incorporated. Majority, though, split. There's no single 5-vote majority. 4 justices, Roberts, Alito, Scalia, and Kennedy, held that the Second Amendment should be incorporated through the Due Process Clause of the 14th Amendment, is what's known as substantive due process. This is a right that's so fundamental, the states cannot deprive you of it. Justice Thomas cast a deciding 5th vote. And the 5th vote explained that the right to bear arms was a privilege or immunity of citizenship. So he would have gone back to the Cruikshank case, as well as the slaughterhouse cases, and said we need to reinvigorate the privileges or immunities clause. Now, I think Thomas is right, he usually is. Thomas says what other people don't want to say. That's the truth. He says what other people are unwilling or afraid of saying. So Thomas was right, but he provided the foundational vote. Because look, even if you still accept the sort of militia reading of the Second Amendment in the 1790s, look at what happened in the 1800s. You have the Dred Scott decision. You have the Freedmen's Bureau Act. You have the Civil Rights Act of 1866, right? You have the 14th Amendment. All this discussion how the right to bear arms was essential for individuals to save themselves from the Klan, right? This is not a militia-based right. It's a different right. It's a different conception. So even if you think Heller was wrong, McDonald has to be correct. McDonald v. Chicago ruled that the Second Amendment does limit state power. All right, so Heller was in 2008. I am dating myself, but I was a rising 3L, right, where many of you are, right? I was actually a research assistant for Professor Nelson Lund in 2008 when he wrote his amicus brief in Heller, which was a very influential brief. I take no credit, but it was kind of cool to do it. So I remember waking up, and I was a summer associate. My second year of summer, I was actually in California at the time. I woke up like at 4 in the morning to get ready for the Supreme Court opinions, because it's East Coast, West Coast. And I was like, oh my God, this is so awesome, Second Amendment, rah, 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 rah. But Nelson Lund, who was, again, my professor and a brilliant scholar on guns, said, don't celebrate too soon. Don't spike the football. Because there was some language, in Heller that Nelson was like, watch out, this is not so good. Even though the court declared unconstitutional the federal handgun ban, there was some dicta, if you will, that said the states and the government saw some latitude. The court wrote, I'll read you this famous quote, "Nothing in our opinion should be taken to cast doubt on long-standing prohibitions of the possession of firearms by felons and the mentally ill." Okay? Or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings. Okay, limitation on carrying, or laws imposing conditions and qualifications on the commercial sale of arms. Okay, sale of arms. And then there was this language that the guns protected are those in common use. Okay, and the court said dangerous and unusual weapons can be banned. Okay, so we have this decision which seems on its face to recognize this right to bear arms, but it basically says, but everything else is okay, right? Every other restriction is fine. And Nelson Lund and others warned that Heller was not the victory we thought it was. I think they were right. So Heller was in 2008. McDonald came in 2010. Right, so again, we're talking almost 12, 13 years ago at this point. McDonald added nothing about the scope of the Second Amendment, just says whatever Heller says, we incorporate to the states. And then we have this period where it's like, wait a minute, we have this new constitutional right, let's see what it means. Challenges were filed to bans on concealed carry. Challenges were filed to restrictions on different kinds of so-called assault rifles. Challenges were filed to restrictions on high-capacity magazines. Challenges were filed to restrictions on people, non-violent felons. Martha Stewart, why can't she own a gun, right? Challenges were filed to owners' restrictions on firearm sales, about buying guns out of state. And with only a couple exceptions, every single challenge failed. And even where they prevailed in the district court, the circuit court reversed it. And even where the circuit court reversed it, the en banc circuit court reversed that. Every single significant challenge failed. And petitions for certiorari were filed. The cases were appealed to the Supreme Court. Parties said, please, Supreme Court, provide some guidance. Tell us what Heller means. Tell us about the right of carry. Tell us about different types of weapons that are protected. Supreme Court, please give us some guidance for what level of scrutiny ought to be applied to gun control restrictions. And the Supreme Court said nothing. Silence. Crickets. Cert denied, cert denied, cert denied, cert denied. I lost count. There were dozens of cert denials. Dozens. Splits couldn't form because courts consistently ruled against the Second Amendment, and the Supreme Court did nothing to stop it. Around 2015 or so, Justice Thomas, actually it was 2014, I think, started dissenting from the denial of certiorari, saying, hey, wait a minute, we got the Second Amendment. We should take a case and decide what it means. We decide lots of other cases involving abortion and free speech and religion and every other Fourth Amendment, search and seizure, every other constitutional right. The court takes cases on a regular basis, but not guns. And then Justice Scalia started joining him. And then Justice Scalia passed. And then Justice Gorsuch started joining. And Justice Alito started joining. And Justice Kavanaugh started joining. Yet, we still were not getting a gun case in the docket. Finally, in 2019, the Supreme Court granted a case from New York, the New York State rifle and pistol case. This was an insane law in New York where the law made no sense. That if you wanted to go to a target range and you lived in New York, you could only go to a target range in New York City. And you had to keep the gun locked in your trunk, but only a city range. Now, out here, it's like, well, what's the big deal? New York City is very big, right? Getting from one part of New York to another with a gun is almost impossible because of traffic, there's no parking. You can't drive in New York the way you would drive anywhere else. For example, I grew up in Staten Island. It was maybe a 15-minute drive from Staten Island to a gun range in New Jersey. But you'd have to drive maybe 90 minutes to a gun range in the Bronx instead. Well, if you went to a target shooting competition in Pennsylvania, you couldn't do that with your gun. This law was completely irrational. It made no sense. It was designed purely as punitive, right? That you couldn't even train with the weapon you're supposed to keep in your house. I'm not talking about carrying outside. Keeping it locked in your trunk. You couldn't drive to a range out of state, even if that state allowed you to drive there. Nuts. Okay, insane. If you had a second house, you couldn't carry a gun from one house to another. The law was irrational. But the lower courts gladly upheld it under intermediate scrutiny. That's what they always do. It's always intermediate scrutiny. Okay. Second Circuit upheld the law, intermediate scrutiny. Then the Supreme Court grants cert. And then, what does New York do? They repeal the law. Not only does the city repeal the law, the state enacts the law, making it impossible for the city to reenact the law. So they basically wipe it from the face. It's like Carthage. They salted the earth, right? You cannot reenact this law. Why? They want to moot the case. They were so afraid of the Supreme Court ruling on guns that they basically destroyed their own law, which made no sense. And the Supreme Court held that, yes, it became moot. 3 judges dissented, saying this is insane, that New York's obviously trying to manipulate our docket. We should not countenance this abuse of authority. All right. But then another case from New York comes up, New York State Rifle and Pistol Association versus Bruin, B-R-U-E-N. And that's the case before the court now. This is actually about concealed carry, right? In New York, if you want to carry a gun outside the home, you must pass a background check, you must take various proficiency tests, and oh, by the way, you must show special cause. What does special cause mean? You need some special reason beyond the normal of why you should get a gun. This is a completely discretionary standard. Local officials have complete discretion over how they grant this or not. Merely saying you want to defend yourself is not enough. Saying you live in a high crime area, not enough. Now, what happens, of course, is that if you're an important person, a celebrity, an athlete, right? If you're someone that politicians like, you'll get your permit. But if you're a regular person, like me and you, you're not getting your permit. It's like in New York, if you're Kyrie Irving, oh, you need a vaccine. Everyone else gets a vaccine, right? This is how things work in New York, right? There's special privileges for those who are wealthy and powerful. It's like the exact opposite of what you think in a Marxist city, right? But this is how New York rolls. It's true. It's insane. It's silly. He's like, well, he makes a lot of money, so we can give him, an exemption from the vaccine requirement. But everyone, yeah, if you actually see this, there actually are waitresses at Yankee Stadium who are fired for not getting vaccinated. Meanwhile, the athletes are allowed in the field. So try to figure that one out. All right. So the New York rifle case was argued back in November, around the same time I was here earlier this year. And the case is this: can New York impose a special cause requirement on the right to bear arms, right? Can the state require you show some sort of special cause? So here we have a couple legal issues, right? One, Heller didn't directly at least address carry. Heller said the government can ban carry in so-called sensitive places. Sensitive places. That would seem to imply that there are some non-sensitive places, right? That's how logic works, right? There's sensitive places or non-sensitive places. Right? Not everything's a government building. Not everything's a school. Right? Not everything's a park. But Heller didn't squarely hold this. There is also a lot more case law which involves bans on concealed carry. Throughout the 1800s, states often banned concealed carry, but they allowed open carry. And so here's a bit of history which you may not know. Historically, concealed carry was viewed as deceptive, right? You were hiding your gun to engage in mischief. Open carrying was sort of the honorable thing to do because you show people what you had. Today it's almost the opposite. The open carry people are the ones who piss people off. And if you're concealed carrying 30-06 or 30-7, if you're concealed carrying, it's, you never even know about it. Also, guns are much smaller today. You can't conceal them. Back in the day, most guns weren't even concealable because they were big, right? You couldn't put a rifle in your pocket. So the court will likely say, and I think this is pretty solid, that the Second Amendment protects the right to bear arms outside the home. What happens next, though, gets tricky. How they get there is hard. If the court chooses scrutiny, and they just say we use intermediate scrutiny to get there, that will basically give the lower courts free range to basically uphold every gun control law, right? They've used intermediate scrutiny to uphold everything. If the court uses strict scrutiny, that means almost all gun laws are unconstitutional. So I think the more likely path of the court says we use a what you might call a historical approach. This is what Justice Kavanaugh seems to like. Right? We look to history. And if there's a strong, deeply rooted history concerning the right to bear arms, then the state cannot ban this public carry. But wait, I'm not done yet. Even if the Second Amendment protects the right to bear arms in public, what do we do with New York's good cause requirement, right? Maybe New York's good cause requirement is a valid way to enforce that Second Amendment. And here's where the case might get messy. This term, the Supreme Court's busy. They have lots of things on their docket. The big one we talked about back in November is abortion. And just bear with me for a minute. If the Supreme Court overrules Roe v. Wade, right, they overrule that case, and they also tell New York, yeah, you can't ban guns, right? So in other words, Mississippi, you guys can ban abortion, but New York, you can't ban guns. The court doesn't like that sort of thing because it looks like they're just favoring one side of the aisle. So it's entirely possible the court overrules Roe that they don't strike down, so to speak, the New York gun law. So I think, and I go back and forth almost every day, most likely course in the gun case is the court says, well, New York, the Second Circuit, you applied the wrong standard. Here's the correct standard, take another look at the law. In other words, the court won't say what to do. They'll say, here, remand it, take another look. And that sort of delays the inevitable, right? It kicks the can down the road and lets someone else make the decision over how to restrict the right to bear arms, right? The lower court can make the decision. And if the court does that, the court says, well, it wasn't us, the Second Circuit, or the Southern District of New York, whichever court it was, held the law unconstitutional. All right. But what happens next, right? So I'm going to assume, and I think it's a safe assumption, that the court holds the right to carry outside the home. What are the other issues in the horizon? Well, one issue is actually restoration of gun rights, especially for nonviolent felons. As it stands now, if you are a nonviolent felon, unless the Attorney General takes some action, you'll never get your gun rights back. When Judge Barrett in the Seventh Circuit, showed a very good opinion on the circuit court, explaining that there is no historical tradition of the Second Amendment being denied to nonviolent felons, right? If you were a violent felon, okay, you can have your gun right taken away. But if you had, think of like money laundering or like, tax fraud or something that, obviously is trivial, but you don't pose a threat to anyone else. Why are you losing your rights forever? So I think one avenue is a challenge brought by a nonviolent felon. And generally, people on the left are very much pro-criminal justice reform, right? Pro-rights of the accused, except involving guns. In fact, a group of public defenders from the Bronx filed a brief in the New York case, and they were criticized and dragged by Slate and other groups, saying, wow, these public defenders are not progressive. They're favoring gun rights. Who do you think is getting arrested for gun possession? Minorities, right? They're the ones getting arrested for these crimes. They're the ones getting bagged. They're the ones living in these neighborhoods who won't be able to keep a gun to defend themselves, right? So the nonviolent felon issue may actually have some juice. And we get to the other issues, right? Long AR-15s, high-capacity magazines, right? Which means like 10, which is not very high capacity if you ask me, right? High capacity is like 50 if you ask me, but in most states, high capacity means 10 rounds. The drums, those that capacity ones, right? The court has never shown a willingness to take these cases. So I think those cases simply will sort of fall by the wayside. All right. A few other sort of related issues which I want to touch, and we'll go to Q&A shortly. Ghost guns, right? And this is an issue which I have a lot of experience with. I've actually represented in court Defense Distributed. Defense Distributed is a firm that develops the blueprints to make 3D printed firearms. I've represented them in court now for years. The Biden administration is trying to take action to prohibit so-called ghost guns. They want to make it that it's basically illegal to make your own weapon from a gun kit. They want to make it so that any a firearm must have a serial number even put on a gun kit with parts. The challenge to these laws will probably not focus on the Second Amendment, but actually on various aspects of federal law. For the longest time, federal law says that the federal government can prohibit a gun that's mostly complete, what's called an 80%, right? So if you have a receiver of a gun that's like 80% finished, the feds can regulate it. But now the feds are saying that even a block of aluminum, which can be manufactured into a gun, is now a gun part. And I think you're going a bit too far for the statute. So I think at some point the Biden regulations will be halted in the courts and won't really go anywhere. All right. I think I covered everything. So that's the current state of the Second Amendment. We have some time for questions. I'm happy to hear from you all. Thank you so much. Yep, in the back.
So HCF is one of the key forms for the suppressors and silencers now, and it has lowered the time frame from individual buyer to get from a dealer, assuming everything's good on the background, all that. On one hand, it looks like they're kind of helping you, the pro-gun guys like myself, but on the other hand, what you're talking about is they're also possibly going to regulate upper receivers and component kits.
Yeah.
How do they justify this in their own way of thinking? I mean, it's kind of a being of two minds. Yeah, you can have a silencer, but you can't have the parts to fix the difference.
Yeah, so I think thank you for the question. And there probably were some terms used people may not know. A silencer or suppressor is a device you put at the edge of a gun, and it basically mutes the sound. You would think like in the movies, like, pew, pew, pew. No, that's not how it works, right? The purpose of these suppressors today, at least, is for people who've been hearing loss. Am I fair by saying that?
Yeah, I can hear you.
Yeah. I mean, guns are loud. Yeah, thank you. You heard my question at least, right? Guns are real loud. So you put these little things at the end of your gun. It sort of like suppresses the sound a little bit, not enough. But most people who are professional target shooters have hearing loss. It's pretty common. But the feds treat the suppressors like this dangerous device. You're like a ninja assassin, like Mission Impossible style, right? Which is just nonsense. They also regulate various parts of the gun. So an AR-15 is this popular rifle and has different parts. The part the government usually cares about is the lower receiver. It's basically this block of metal in the bottom of the gun that kind of holds everything together. And that's what the government usually cares about. The upper part and all the other components are just basically inanimate blocks of metal. They don't really care about it. What the feds are doing now is moving to regulate not just the lower receiver, but every aspect of the gun, right? And I'm talking about a block of aluminum that you could fashion into a receiver is now going to be considered a gun part. These kits, which you can sort of buy online and drill your holes and do things, are now gun parts. These are not going to be the Second Amendment cases, but I think they're going to have a huge problem on statutory law. I don't think the statute reaches far enough to treat an inanimate block of aluminum, a solid aluminum block, as a gun part. Now, I say this with some interest. The company I represent, Defense Distributed, makes a device called a ghost gunner, right? It's basically a milling machine as a drill. If you put a block of aluminum in this thing, it drills all the holes, makes a perfectly usable gun part. I'm not talking plastic 3D printed guns. Those are awful. They're terrible guns. This is actually metal. So if the feds really try to make it illegal to make a block of aluminum, then maybe DD's in trouble, but it's going to be very hard to do that one. Okay. Yes, I hope I answered your question. Yes, over here.
I've heard, pardon me, this goes to ATF, reconsidering their opinions on what certain parts are or aren't. Notably, right now, things like the FRT, stocks, maybe binary triggers. I've heard Chevron voucher from a lot of message which ATF might defend that. I don't know a lot about that though. Can you explain that? Or
You have microphones? That's pretty cool.
yes.
I was like, how did I hear? I was like, wow, this guy's a loud voice, but he has a mic. Okay. I didn't see because he was pushing this button. I go, oh, that's kind of cool. Like, this guy's got a loud voice. Right. So the question was about bump stocks. I'll just take a little bit. So a bump stock is a device that sort of, I want to answer carefully, mimics a machine gun, right? Usually with a gun, you push the trigger once and a single bullet comes out. With an automatic weapon, or what you might call a machine gun, you push the trigger once and it sprays, boom, 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 right? The bump stock is this, it's like a brace you mount to the gun, and it basically, you keep your finger still, but the gun goes back and forth, back and forth, back and forth, so you're basically pushing the trigger over and over again. If you remember, there was a mass killing in Las Vegas several years ago at a hotel. A guy basically stood in a hotel and just mowed down people from his windows. A tragic thing. He used a bump stock. After the bump stock was sort of came into the fore, the Trump administration, of all people, said we're going to ban the bump stocks. But there was no actual statute allowing them to do this, right? It was not an automatic weapon. And for the longest time, the feds had said a bump stock is not an automatic weapon. So ATF issued a regulation reinterpreting the statute, saying, well, we now understand the meaning of automatic to be a little bit different, and automatic now includes bump stocks. This was litigated in the courts. I filed amicus briefs, which were unsuccessful, arguing that this was not a valid reading of the statute. The statute did not treat them. Some courts use what's called Chevron Deference. What's Chevron Deference? It's an administrative law doctrine that if a statute is ambiguous, agencies can adopt reasonable interpretations of the statute, and the courts will defer to those reasonable interpretations. A number of courts said that the meaning of automatic was in fact ambiguous, and they would defer. It's ironic because the Trump administration didn't want Chevron deference. They said we don't want to use it, but the courts ruled on that basis anyway. It's also not clear if Chevron applies in the criminal context. You have like the rule of lenity and other principles, which suggest you don't use deference, but it involves guns, so who cares, right? The bump stock rule should have been stopped, but of course the lower courts upheld it. In fact, the Sixth Circuit, in a very weird split, upheld it, and the Supreme Court will not touch it. Gorsuch, I think, and Thomas had dissent saying we need to look at this bump stock issue. They didn't. But the Chevron issue will be useful for the ghost gun regulation, right? ATF has interpreted their guidance the same way for decades, but all of a sudden Biden said, we'll do something else. I think you should be very skeptical when an agency changes a longstanding regulation, and I don't think Chevron deference is warranted, right? Nothing changed. The statute's the same. We didn't just gain wisdom how to read it. It's not been ambiguous, and I think the court should rule against those regs, but we'll see what happens. All right, who else wants to push their button? Yeah, right over there. That's so cool, he has buttons. I gotta tell you, in some schools with auditoriums, you can't hear a damn thing, so this is actually really good.
So I have a question regarding, so Heller had some data about like actual definition of arms and how, I guess like how that applies, what they looked at. Obviously, there are specifically handguns. So I was curious as to your thoughts about, I guess what we touched on, like how far that definition of arms expands. Because I mean, obviously you need a handgun for self-defense, but once you start looking at more, I mean, automatic weapons and get things further, you know, how, I mean, because at the time of founding, guns and I guess machine guns like that obviously didn't exist, but it was the same thing that the military had, and obviously now it seems like they don't interpret that to be the same as what the military would have in today's age. So what exactly do you think, in your personal opinion, what's important to do with the definition of arms?
Sure. So let me answer the question more broadly, right? Obviously, the Second Amendment, the Bill of Rights, was written a long time ago. When the Bill of Rights was written, there were no computers, there was no telephones, there was no internet. And yet the courts have been able to apply the First Amendment to technology that didn't exist, right? Just magically they've been able to do it. I don't think guns are that different, right? We can take different models. What is the lineal descendant, right, of the rifle used at the time? I mean, if we want to be frank, if there's actually a weapon that the Second protects, it's probably the AR-15. It's not the handgun, because that's the closest thing we have to military usage, the M4 rifle. So really, the argument for the Second Amendment is greater for an AR-15 than for a handgun. Go figure. It's almost backwards than people think today. But the Heller court was very, very dodgy on this issue. And they said, well, we look to the weapons that are in common use. All right, well, then again, there's, I don't know, 100 million handguns in possession, tens of millions of AR-15s in possession. That's pretty damn common. And these are very commonly held weapons. So I think by any measure, the handgun, high-capacity magazines, and these are standard issue 10 rounds, right? This is not like unusual. These are all in common use. So if you take Heller seriously, almost every gun that people want to own will be in common use. Is a 3D printed plastic firearm in common use? Well, maybe a different argument, right? But for at least the guns people own, handguns, AR-15s, those are pretty easy.
Any other questions?
I've seen, because I follow Leftist and Ghost Hunters and other organizations kind of closely, the Aussie and the FGC and so forth. I've also heard an argument, and I'm curious about your opinions on it, that separate from the Second Amendment issue, there's also a First Amendment issue regarding the actual code that represents the instructions for an handheld, the instructions for a 3D printer, that ignoring that's weapon or not, there's still a free speech issue there.
Sure. Yeah, happy to address that. So again, I, for full disclosure, I'm a lawyer for Defense Distributed. I've been one of the lawyers for, oh my God, 7 or 8 years now. It feels like forever. Our arguments are actually not primarily about the Second Amendment. They're in the case, but sort of in the background. Our primary argument is the First Amendment. What Defense Distributed does, in part, is they put files on the internet. And these are files that can be used to develop 3D guns on your own. States, New Jersey and others, try to restrict the sharing of this information. And we've argued that this violates the First Amendment. We've been litigating this issue now for 7 or 8 years. We are still looking for our first ruling on the merits. It's amazing. that the other guy's been able to dodge this issue for almost 8 years. It's stunning how long this goes on for. We actually just got a victory in the Fifth Circuit, a couple weeks ago, and the district court and the Fifth Circuit said, Fifth Circuit, proceed to a PI quickly. Still waiting for an order. The Western District of Texas, the Austin Division is like my home. I never leave that court. It's Hotel California. I can never check out. It's dreadful. No, I shouldn't say that. That's mean, but it's just, we've been litigating this case forever. Based on the First Amendment. Yeah, you want to follow? Please.
Well, I was just kind of just broadly the argument that code is speech.
Yes. Yeah. I mean, our argument is that code is speech, right? And it's not just code like zeros and ones. The files that defense attributed shares are effectively CAD files. You can view them on the screen. They're 3 dimensions. You can rotate them. You can manipulate them. This is no different than drawing on a piece of paper, just a little more sophisticated. Right? This is speech. And I hope and I pray that someday courts will be willing to recognize this principle, but guns. So we keep fighting along. Anything else? All right.
If I could bug you again, then
last one. Okay, go for it. Go for it. Yeah, one more. Okay.
This is a much more edge issue, but I saw brought up actually called Colfax Massacre or even Montreal. Who's this? Colfax Massacre in Montreal. They're more, they're much like an active community per se, but an argument they had was they presented on the show was that this is definitely probably beyond what's going on here, but that segment also relates to and protects what they refer to as digital arms, that is malicious software.
Not into that. It's. Let's say you code a virus that can, take down a nuclear power plant, right? That's just as dangerous as a EMP, right? I haven't given much thought to whether this sort of dangerous software could actually protect this code. I just haven't thought about it too much. Thanks so much. Thank you so much.